Hi, my name is Vigines Shankar and my MATRIC number 254481. Today I'm going to talk about the Sunny Hang versus PP case which had happened in Singapore in year 1966. And I will explain about the brief fact what happened in this case, and it will confine more confined to the circumstantial evidence in this case. In this case, the appellant was convicted for murder of one Jenny Chok, which is lower, and was sentenced to death. According to the prosecution, the offence was committed near the sea of Singapore. The appellant had hired a sampan from a boatman, and on his direction, the boatman brought the appellant and the girl to the place where he dropped the anchor to scuba diving. According to the appellant, the motive to go there was to collect corals, but the prosecution contended that his real intention was to murder the girl, and in pursuance of that intention, he had assisted to put on the diving equipment and allowed her, she is a basic diver, novice diver, to go down alone wearing a flipper which had been cut by the appellant, and he knows that it was dangerous and hazardous to dive in alone in that dangerous water flow, but he had silent on that. So the main intention is to make her to death, and the evidence was given that the girl had been insured against accidents which several insurance companies, and that sum of the policy had been renewed by the appellant 24 hours after disappearance of the Jenny. And although he had not renewed or extended his own insurance policy, but based on the circumstantial evidence, it shows that the accused had done this offence. Based on the circumstantial evidence, it shows that the main intention is to recover the insurance money from the appellant, from the accused is lower. So these are the main important brief facts that had been confined in this case. So this is second part. In this second part, I feel what is my feeling is, I feel that based on the circumstantial evidence that had been obtained in this case is strong enough to secure a guilty charge upon the appellant. I will say there is a motive preparation and previous or subsequent conduct under Section 8 and Section 5 of Evidence Act 1950. So firstly, the appellant has a motive to murder is lower in order to give insurance money. Motive is that which induce a person to do particular act. In this case, the appellant had been made a bankrupt. He was in need of money, and that could be a motive for this crime. Jenny was insured against accidents with several insurance companies. The sum total was $450,000. Thus, we can see all the cost appellant that have a motive to murder the Jenny in order to get the money itself, because that is the main intention of the accused. Secondly, the appellants had showed its preparation in this case. Preparation is a preliminary act which leads to commission of the offence. In this case, the appellant followed Jenny to go down into the water at the island. According to an expert witness, it was not safe for the novice scuba diver to dive alone. Jenny had a little experience of what is called scuba diving and might fairly be described as a novice scuba diver. This is known to be known to appellant that she could be facing a problem in diving alone in that dangerous water, but he just silent on that because the intention was to murder her. So based on the above points on this circumstantial evidence, it's showing that the appellant had made a preparation on murdering Jenny. He knows that the water near Pulau Dua, the island, was dangerous, and it surely will endanger the safety of the Jenny. He insisted to let her to do scuba diving alone. And the most important part, that the flipper has been cut by the knife or sharp instrument. So this can show the preparation of Sunny, who wanted a lover to death. And he had within 24 hours after her death, he has claimed all the insurance money. So thus, based on this, it can be shown that there is a preparation action, and based on the circumstantial evidence, I feel that he really murdered Jenny. Okay, I will explain about the third part, which is evaluation. Based on this case, the appellant had been charged murder, and with complying the circumstantial evidence that had been obtained by the prosecution, and the defense counsel for this case had failed to raise the reasonable doubt, because Based on this case, there was a much complication where the circumstantial evidence had been complied together like a rope that is twisted around, which means in this case the circumstantial evidence is very very close to the guilty of for the offense of this accused, where there is a preparatory action done by the accused to done this offense murder to his lover. Thus the court held that he is liable and convict for the offense of murder based on the circumstantial evidence that had been obtained. And for this legal circumstantial evidence, the legal provisions can be used, that is section 5 evidence 6, which it says that if the evidence is relevant, then it is relevant and circumstantial evidence is admissible. It can be cited with the case of a Yap Boon Hai, where the court relied fully on circumstantial evidence in convicting the accused of murder by setting fire to his family home. The circumstantial evidence was neighbor had saw he had taken the staircase, he had bought the petrol from the petrol bunk. His sister-in-law and brother testified that there is argument, and the officer had saw there is a complaint, there is a fire started by the accused, and these are all the circumstantial evidence that had been found in this case. Thus the accused had been found to be liable in this case. And otherwise, in the case of PP versus Hanif Bashri Abdul Rahman, in this case there was a contradict to the circumstantial evidence. Thus the accused had been not found to be guilty and had been acquitted. So thus this is the valuation of the decision of the court and the laws that complying with the circumstantial evidence. Now we look at the conclusion and the way forward to improve the evidentiary aspect in circumstantial evidence in court. As a conclusion, the different pieces of circumstantial evidence may be required so that each corroborates the conclusion drawn from each of the evidence, and it will particularly bind, and it shows that the accused had committed that particular offense. It is contradict to the direct evidence, which direct evidence can look with the detail and a specific evidence to convict a person. And for me, if a person on trial went out and bought a gun and bullets on the day before the victim was shot, the prosecution will want the judge or jury to infer that accused bought the gun to shoot the victim, and now telling that circumstantial evidence can convince people or to believe that someone is innocent or guilty, but they itself cannot prove the event took place. Thus, for me, direct evidence is much more practicable to be applied in the court in the aspect of evidentiary aspect. Okay, now we look at the ways to improve the evidentiary aspect in the matters of circumstantial evidence in court. I think that judge have the sole responsibilities of these matters of law to uphold the evidence regarding the circumstantial evidence in court. The judge must sort out the evidence presented at trial, which there is a conflict, decide which version to be believed, and the judge must evaluate the credibility of the witness offering different versions of event to combine it and to look who is the real accused, who is the real offender of in that particular offense. The jurors also must able to observe the demeanor of a witness. Demeanor includes the body language and whether the witness acted in a cooperative or exertive fashion. Lawyers on a cross-examination also must done the way to attempt to attack the credibility or believability of witness, where it can establish the truthfulness of this case. It can show whether it have a motive to fabricate the evidence. It will establish that the credibility and the believability of the witness during this case. Thus, the conviction will be the conviction will be more fair to the accused. So the court, the judge, and the lawyers have the sole responsibilities to uphold this and bring this forward, bring this circumstantial evidence to way forward to improve it. With that, thank you.